live streams like I do, and on the YouTube feed, they need to not let people comment. Yeah, while it's running. There are a bunch of folks who get on it and they're saying stuff that's getting to be a little unsafe for people. So do we know what courtroom Judge Manning's in? I mean, she's mobile. She bounces around from courtroom, but if you can track her, you know who she is? Yeah. So her YouTube feed, just like mine right now, here's the YouTube feed. In a minute, the groupies are going to be on. I don't care. They're doing their own, but for hers, they want it. No more comments. Fantastic. Thank you. Yeah, I texted a Dejuan just because it hit me while I was walking my dogs. I wasn't trying to go outside the communication, but it's probably like 10:45. But I'm glad it got it when you got Judge Manning's comments off, because then I'll let the people who reached out were pretty upset. And so I want to let them know, hey, we took care of it. Thank you. Yeah, but she does bounce around. Sometimes it's a 6. She's on a 6, but it's all Slayton stuff. All right, can we bring Mr. Dill out now, please? Excellent. Everything's falling into place. What's in there? It all goes back. Especially the disc, because that's what, no, they don't, but that's what reminds them, hey, I want to watch what's on this disc. So really what doesn't go back would be if there's a continuing witness. I don't know. I mean, maybe the ME report or the certainly the convictions don't, based on the stipulations. Okay. Well, the text messages go back, but we'll get all that on the record. But I'm familiar with that case law. Okay. Ms. Rivers, let me know when you are ready. Okay. We'll get back on the record in State versus Dill, 22 SC 181085. It is about 9 o'clock on Thursday, the 15th. Mr. Dill is present. Good morning, Mr. Dill. With his 2 lawyers. We have our 2 prosecutors here. Deputy Gordon tells me our jurors are all here as well. So folks are being where they need to be. Ms. Feely, did you get a chance to review the verdict form? Any issues with it? Ms. Willingham, did you review the verdict form? Any issues with it? We've got a verdict form. You both have a hard copy of the final charge that I'll be sharing with the jury in just a few minutes. The one in my hand will go out with the jury. There will also be to them anything we need to talk about concerning the charge at this point, Ms. Willingham. No. Ms. Feely. No. It reflects the edits we went over yesterday. I made a few stylistic changes as I was looking at what was on the PowerPoint in here, maybe removing a "the" somewhere, but I didn't add any new charges. And certainly didn't remove any charges. Trying to think if there was anything else we needed to cover. Ms. Feely, anything from the defense before we bring the jury in? Oh, we have to talk about the exhibits that go out. So tell me, Ms. Feely, if there were any disagreements as to what goes out. Not some statements at 118 the autopsy report out. Okay. That's pretty clear. And then I understand the court had already complied on text messages, which states 1 through 19. Okay. Our position that doesn't fall under the 2020 Keller case because it was read into the record by a witness, and we think it will place unfair and undue influence on this written account of folks. That's fact. So we're asking to not send this back. They can certainly ask to look at it. Okay. Ms. Willingham or Ms. Beza, the ME exam, how does that go back with the jury?
Under Young v. State, 292 Georgia 433, it reads, finally, Young asserts that, I'm sorry, let me just skip down to the holding. The ultimate issue for the jury in that case at the time was that it wasn't whether Bowers was a victim of a homicide, but it was because it was undisputed that someone killed him 11 times. And the autopsy report set out no opinion on that. That does not make sense to me.
So in this case, the autopsy report would violate the continuing.
What? Okay. Your Honor, no objection to the autopsy report, not going back.
Okay. What about the text messages 1 through 19?
The text messages. I'm sorry. Hold on, Your Honor. Go back to that case law.
Want me to do this one?
Yeah, because I'm still reading.
Okay. Your Honor, in regards to the text messages, Nix v. State 354 Georgia App 47, it's a 2020 case that the trial court in that case concluded that it would violate the continuing witness rule for the jury to be provided with 455 pages of text messages sent between Nix and JN, the victim, from 2018 to 2015. And this court concluded, the appellate court concluded that this was error, as the text messages were original documentary evidence demonstrating the type of relationship that Nix and JN had during the time frame when the crime was committed. Here, these text messages via Instagram, essentially, demonstrate the type of relationship that Tatiana, the named victim in the indictment, and the defendant had, as in Nix, during this incident and around this incident. Therefore, it's the state's position that it would not violate the continuing witness rule for these text messages to the defendant. And then there's another text message to the mom.
Okay. And
The mom might, I would think, as it's arguable that the text message to the mom also demonstrates the relationship between the defendant and to Tatiana. So it's the state's position that all of them would go back. Had to think through that for a second.
Got it. Okay. So Ms. Feely, you think that in this case, we fall outside the reach of Nix, and then you cited to Keller, which is 308 Georgia 492, which references Nix and a few other cases, because the difference here is that Ms. Willis Riley actually read most of, I don't know if it was every word, there weren't a lot of words, it was mostly just missed calls, but certainly the majority of the content of the Instagram exchange between Ms. Willis Riley and your client, Ms. Willis Riley read into the record. And so you're saying these text messages then would become a transcript of her testimony effectively?
So essentially she testified to the nature of the relationship, including being in part of difficulty. So it's our intention that this just places undue influence on Tatiana's oral testimony that she gave, which included reading the messages.
Okay. Got it. Just looking at one more thing. And Ms. Willingham, what I took at the end of your presentation about the medical examiner's report is you are no longer opposing keeping it out of the jury room.
Correct, Your Honor.
Okay.
And Your Honor, just one more thing about Nix.
I'm listening.
Nix further states that there's no indication that the text messages contain testimonial evidence or constituted written versions of each person's testimony, such as would be the case with an affidavit, deposition, or sworn statement. That is not what we have here in the text messages. They're mainly missed calls and then subsequent conversations back and forth between the defendant and Tatiana, demonstrating, as Nick says, the type of relationship.
Okay. I think under Keller and Nix, it is proper to have the text messages, the Instagram exchange, go back with the jury. Otherwise, if the party interested in having original documentary evidence, which is what these text messages are, go back with the jury, they would be prohibited from having a witness ever share with the jury orally what was in that document. And I don't see that as being the rule. If we just make it real simple, it was a letter that Mr. Dill wrote to Ms. Willis Riley saying, when you're with someone else, I get angry, I'm going to do something about it sometime. If he wrote a letter like that. The rule that Ms. Feely is advocating is that if the handwriting was kind of hard to read, but Ms. Willis Riley could read the handwriting, if she read it into the record, then that letter couldn't go out because it would then have become her testimony. And I don't think that's what the case law says. I think that the case law says because these texts were created when they were, they're original documents, and they're not a memorialization of someone's testimony in preparation for litigation, like an affidavit or a deposition, that they can go out. So states 1 through 19, were those the numbers? Those will go out with the jury over objection from the defense, and the medical examiner's report for now will stay with the convictions. And was there anything else? Or the indictment, plea, and sentence for the 2 convictions? That's the other things that are staying out.
That is correct, Your Honor, and that states 163 and 164.
Okay, that's the right decision. Okay, so 3 things stay out, everything else goes with the jury, to include the bags that have shell casings in them and the DVDs. Jurors are entitled to look at that. If they want to play the DVD, i.e. watch video again, they'll send a note, and we will accommodate them by having the video play out here. Ms. Willingham, anything else before we bring the jurors out?
Nothing further.
Ms. Feely?
Yes, Your Honor, we would like to put on the record that now that the state's text messages are going back, we just want to further highlight the prejudice of our text message not being allowed, and also want to put on the record that for it to have come out as untimely disclosure and court to sustain an objection, there would have had to have been some bad faith, and also that the state was prejudiced. And this was text messages from the exact date, exact time of Instagram messages. So for the state to object to that, and now they get to have their text messages go back, we just wanted to highlight for appellate purposes.
Okay, and I want the record to be extra clear on this because it is clear to me that if there is an appeal from the defense side, some appellate lawyer will be harping on that. It's not a text message that got kept out. It is a screenshot of what you purport is your client's phone showing a missed phone call. I'm not saying it's not prejudicial because of that, but the record needs to be very clear, apples and oranges. A string of Instagram exchanges, text messages, apparently a screenshot of something from Ms. Willis Riley's Instagram feed, the photo of Mr. Stafford cooking, and then some answered and missed calls. That's what's coming in. That was provided timely in discovery, wasn't sat on inadvertently or advertently. What you sought to get in the middle of a witness's testimony, in the middle of trial, was the screenshot that purported to show that your client missed a phone call, didn't answer it, didn't know it rang, but an incomplete call, that Ms. Willis Riley's phone, whoever had it, tried to call Mr. Dill's phone. Not a text message, no content, a missed call. But right in the middle of when things were hopping around that apartment complex. So you're making your record. I'm just perfecting it for whoever is having to review this. And it is, hopefully, we need to make Defense Exhibit 1 part of the record. So if you would leave it up here when we're done, so it is made part of the record. And I'll admit it as part of the record. It just wasn't shared with the jury.
Yes, and it's on file, so during break off.
Great.
And may I make a brief record regarding the prejudice of it?
You may.
Your Honor, the state would have been 100% prejudiced because we did not.
That's a lot of
receive-
prejudice.
Yeah, because we did not receive this text message.
It's not a text message.
I keep on thinking, you're right. It is a screenshot of the defendant's phone of a missed call. Tatiana had already testified. She had already testified. Her testimony was over. The defendant's mother was on the stand. If the state would have received this pretrial, even after opening statements before our first witness, we would have been able to ask Tatiana about it. It could have been her phone accidentally dialed the number. It could have been an array of things. We just don't know. And so we would have been prejudiced by not being able to ask Tatiana, whose phone apparently made this missed phone call, whether it was an accident, whether it was on purpose, whether it was checking to see if he was even there. So we would have been prejudiced in not being able to dig into and explain that missed phone call to the jury.
Okay, thank you. Ms. Feely, any other topics before we bring the jury in? Okay, thank you. Let's bring the jury in.
Thank you can take it to the court. I think there's a basket.
All right, for the jury. I'll do as the president.
You all can be seated. Good morning, ladies and gentlemen. Thank you for being on time. We covered a couple things while you were back in the jury room. I think we were able to replenish your snack basket, so you weren't hungry while you were waiting on us. There is one piece remaining before you begin deliberating in this case, and it is for me to instruct you on the law that you must apply as you deliberate. I will be reading to you from this document. This is the jury charge. Couple things. One, this document will be going back into the jury room with you. So you are free to take notes as you were throughout the trial. There is some legalese in here. I do my best to make this accessible so that if I was at home reading it around the dinner table, people would get bored pretty quickly, but at least they'd understand what it is I'm reading. But there are certain legal concepts that have certain words hung on them either by the legislature or by the higher courts. So you'll hear me say something like an abandoned and malignant heart. I don't know who talks that way, but that's one phrase I have to use in defining one of the elements of murder. So I try to make this accessible both in terms of the words, but also accessible in the sense you'll have this document during your deliberations. And as I'm reading to you, on the screens will be what I'm reading. Some folks follow along better by looking at a screen rather than listening. Some people like to dual purpose it so you can listen and watch. But this is the charge. It will give you the law that you must follow. You don't get to deviate from this. If it says the element is X, you don't get to decide, no, that's really not a part of that crime. This is going to detail what the state must prove beyond a reasonable doubt as to each of the allegations in the indictment. And it provides some law and a couple other concepts that you need to understand and apply to your role as jurors. When I'm done with the jury charge, you guys will go back, you'll get the evidence, the photos, the text messages, et cetera, to consider as you deliberate. So let's get started. A grand jury has indicted the defendant for murder, felony murder, aggravated assault, aggravated battery, armed robbery, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon. The defendant has entered a plea of not guilty to these charges. Neither the indictment nor the plea of not guilty is evidence. And a reminder, it's not on the screen, you'll have the indictment back there with you. So you'll be able to see again the language of the charges. do one thing here. The defendant is presumed innocent. This presumption remains with the defendant unless it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of one or more of the crimes charged. The state must prove beyond a reasonable doubt every material allegation of the indictment and every element of each crime charged. There is no burden of proof upon the defendant, and the burden never shifts to him to prove anything. If a defense is raised by the evidence, the burden is on the state to negate or disprove that defense beyond a reasonable doubt. The state is not, however, required to prove the defendant's guilt beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's a doubt based upon common sense and reason. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It doesn't mean a vague or arbitrary doubt, but is rather a doubt for which a reason can be given, a reason that arises from your consideration of the evidence, lack of evidence, or conflict in the evidence. If, after considering the evidence, your mind is wavering, unsettled, or unsatisfied, that is a doubt of the law and you must acquit. But if such doubt does not exist as to the defendant's guilt, you would be authorized to convict. Evidence that merely places upon the defendant a grave suspicion of the crimes charged, or that merely raises a speculation about his guilt, is not sufficient to authorize a conviction. It is my responsibility to instruct you on the law. That's what I'm doing right now. You are bound by these instructions. It is your responsibility to determine the facts from the evidence presented. You must then apply the law that I'm giving you to the facts that you find. You must decide this case based only on the evidence presented during trial. That evidence consists of testimony and exhibits. Evidence does not include the indictment or plea of not guilty, anything I've said or the lawyers have said to include their opening and closing remarks, nor does evidence include any of the questions that were asked, only answers that are given. Now, the evidence that you've received may be direct, circumstantial, or both. An example of direct evidence is the testimony of a person who asserts that she has actual knowledge of a fact, like an eyewitness. I was there and I could see that the light was red when the car went through the intersection. Circumstantial evidence is proof of one or more facts that tend to prove or disprove some other fact by inference. Someone walks into the courtroom with an umbrella and it's shaking the umbrella off and there's water on the person. You can't tell in this sort of dungeon of a courtroom that it's raining outside. We don't have any windows, but someone walking in with an umbrella and all wet, that might in your mind be circumstantial evidence that it's raining outside. There's no legal difference in the weight you may give to direct or circumstantial evidence. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. However, you may convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the defendant's guilt beyond a reasonable doubt. You must determine the credibility of the witnesses in this case. In deciding this, you may consider all the evidence, the witnesses' manner of testifying, their basis for knowing the things about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their possible bias for or against a party. The credibility of a witness may be attacked by disproving facts to which the witness testified. You may also consider other evidence offered to attack the credibility or believability of a witness, including evidence of a witness's bias for or against a party. If a witness's credibility has been attacked, you may consider evidence offered to support the credibility of that witness. You heard from a witness who was designated as an expert in this case. That was Dr. Sullivan. Experts are those who, because of their training and experience, possess knowledge in a particular field that is typically not known to the average person. Experts are permitted to give their opinions based upon that training and experience. Testimony of an expert, like that of all witnesses, is to be given only the weight and credit you decide it is entitled to receive. The testimony of a single witness is sufficient to establish a fact. Corroboration of a witness is not required, provided that you find the witness's testimony to be sufficient. Defendants in criminal cases who have no burden to prove anything are not obligated to testify. When, as here, a defendant chooses not to testify, you may not consider that decision in any way in reaching your verdict. The state must prove the identity of the person who committed the crimes charged in this case beyond a reasonable doubt. The defendant does not need to show that another person committed the alleged crimes. And a crime occurs when the law is violated by a defendant's intentional action. Intent is an essential element of every crime. Criminal intent is not the intent to violate the law, but means simply the intent to do the thing that is illegal. Intent may be inferred from the evidence. It may also be inferred when it is the natural and necessary consequence of an act. The defendant is not presumed to have acted with criminal intent, but you may find that intent, or the absence of it, from your consideration of words, conduct, demeanor, motive, and other circumstances connected with the acts for which the defendant is being prosecuted. Evidence of prior difficulties between the defendant and a witness has been admitted only for the purposes of illustrating, if that evidence does, number one, the state of feeling between the defendant and that witness. Two, the reasonableness of any alleged fears of that witness. Three, any possible motive for the defendant's alleged acts. And or four, the defendant's intent on the night in question. Whether this evidence of prior difficulties illustrates these things is a matter for you to determine, but you are not to consider this prior difficulties evidence for any other purpose. Criminal cases must be tried in the county in which the crimes were committed. This question of venue, that is, were the crimes alleged in this indictment committed here in Fulton County, must be proved by the state beyond a reasonable doubt. Murder. For murder, the state must prove that the defendant, number one, caused the death of another person. Two, that he did so unlawfully. And three, that he did so with malice aforethought. It's one of those phrases. The killing must have been done with malice to be murder. However, malice, as the term is used in this context, doesn't necessarily mean ill will or hatred. Rather, it is the unlawful intent to kill. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another. You may also find malice where there does not appear to be a significant provocation, and the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, that is, with unlawful intent, it is a murder regardless of how briefly that malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice, that unlawful intent to kill, was in the defendant's mind at the time of the act that killed, and it moved him to do it, that is enough for the killing to be murder. Proof of motive is not essential to the crime of murder. Evidence of motive, if any, has been admitted for you to determine whether it establishes the defendant's state of mind at the killing. In considering the malice murder charge, that's count 1 of the indictment, you must decide whether the defendant was sufficiently provoked and acted out of passion. If you find this, you may not return a verdict of guilty of malice murder, but you would be authorized to return a verdict of guilty of voluntary manslaughter. The state must prove beyond a reasonable doubt that the offense should not be reduced from murder to voluntary manslaughter. So what is voluntary manslaughter? For voluntary manslaughter, the evidence must show that the defendant, number 1, caused the death of another person. Number 2, under circumstances that would otherwise be murder. 3, but he acted only because of a sudden, violent, and irresistible passion that resulted from serious provocation, which, number 4, was sufficient to excite such passion in a reasonable person. If you decide that enough time passed between the provocation and the killing for a reasonable person to have cooled off and regained judgment, then the killing is not voluntary manslaughter. Felony murder. Just trying to find the indictment. That is counts 2 through 5. For felony murder, the state must prove that the defendant, number 1, caused the death of another person. 2, by committing a felony. The state does not have to show that the defendant acted with malice, with that unlawful intent to kill, to prove felony murder. Aggravated assault, armed robbery, and possession of a firearm by a convicted felon are all felonies. Those are the alleged underlying felonies for each of the 4 counts of felony murder. You may find a defendant guilty of felony murder if you believe that he caused the death of another by committing the felony of aggravated assault, armed robbery, or possession of a firearm by a convicted felon, regardless of whether he intended the death to occur. But there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault, which is count 6. A person commits an assault when he attempts to commit a violent injury to another. A person commits the offense of aggravated assault when he assaults another with a deadly weapon. The state must prove as an essential element of aggravated assault, as it's charged in this case, that the assault was committed with a deadly weapon. And I am telling you that a firearm is a deadly weapon. Aggravated battery. A person commits the offense of aggravated battery when he maliciously, intentionally, causes bodily harm to another by rendering a member of his body useless. And that is count 7. Armed robbery. For armed robbery, the state must prove that the defendant, number 1, took another person's property. 2, from the other person or from the immediate presence of the other person. 3, by using an offensive weapon. And 4, with the intent to commit theft. An offensive weapon is any object that is likely to cause death or serious bodily injury if used against someone. An armed robbery may be committed by shooting and incapacitating the victim first and then taking his property. That is, a conviction for armed robbery is authorized if the evidence supports it beyond a reasonable doubt, regardless of when the intent to take the victim's property arose. However, if the taking of the property occurs after the use of force and is sufficiently separated in time from the use of force, then the use of force does not support a charge of armed robbery, which is why there's a lesser included of robbery. For robbery, the state must prove that the defendant, number 1, took another person's property. 2, from the other person's immediate presence, 3, by force, and 4, with the intent to commit theft. Count 9 charges possession of a firearm during commission of a felony. A person commits the offense of possession of a firearm during the commission of a felony when he possesses a firearm during the commission of a felony. It's one of the most self-explanatory offenses we've got. Murder, felony murder, aggravated assault, aggravated battery, and armed robbery are all felonies. And that term firearm includes any handgun. And finally, in counts 10 and 11, the defendant is charged with possession of a firearm by a convicted felon. A person commits that offense of possession of a firearm by a convicted felon when he possesses a firearm after having been convicted of certain felonies. The term firearm includes any handgun, and the parties have stipulated in this case that the defendant is a convicted felon for purposes of both counts 10 and 11. Now, to that end, you have received evidence in the form of the stipulation of prior convictions of the defendant. You may consider that evidence only as it may support the required element in counts 10 and 11 of conviction of a felony and not for any other purpose. In the jury room, ladies and gentlemen, you will have this verdict form, which your foreperson will fill out. You should consider each count of the indictment individually. The defendant may be found guilty of some, all, or none of the charges. If, after considering the evidence together with the charge I'm giving you now, you should unanimously, all of you, find beyond a reasonable doubt that the defendant did commit in Fulton County any of the crimes alleged in the indictment, you would be authorized to find him guilty of those crimes. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. And this doesn't actually match the verdict form, so follow my spoken words. On the verdict form, for the count where you found the defendant guilty, you would check the blank next to the word guilty. This is an easier form to fill out. You don't have to write the word guilty or the words not guilty. They're already on there. And you have a choice. For example, count 2 says, we find the defendant. And then there's the word guilty with a blank next to it. And then there are the words not guilty with a blank next to it. If you find that the state has proven beyond a reasonable doubt that the defendant is guilty of count 2, and that crime was committed in Fulton County, you would be authorized to check the box guilty. If you do not believe that the defendant is guilty of a particular offense, or if you have any reasonable doubt as to his guilt, then it would be your duty to acquit him, in which the form of your verdict would be, we, the jury, find the defendant not guilty. And you would check not guilty for that count. You wouldn't write the words not guilty in there because they've already been typed. Whatever your verdict is for a particular count, it must be unanimous. Your verdict must also be in writing, in this form, signed by your foreperson and dated. You will notice, this is not on the screen, that for count 1 and for count 8, there are 3 options because we have lesser includeds. So for count 1, murder, guilty of murder, guilty of voluntary manslaughter, or not guilty. Only one option, or none of them if it's a hung jury. You don't check any of those. Similarly, for armed robbery, count 8, guilty of armed robbery, guilty of robbery, not guilty. One option. Ladies and gentlemen, by no ruling or comment that I have made during the course of this trial have I intended to express any opinion about the credibility of witnesses, the strength or weakness of the evidence, or the possible guilt of the defendant. Your verdict must be based solely upon your consideration of the evidence according to the laws I've been giving you in this charge. It is your duty to consider the facts objectively, without favor, affection, or sympathy for anyone. It is also your duty to report to me if you sense that a juror, one of your colleagues, is making decisions based upon improper considerations of race, gender, religion, or sexual orientation. You are the fact finders in this case. You decide what happened in this case. You are not to concern yourselves with punishment. That is a role for me. One of your first jobs in the jury room, where you'll be going very shortly, only 3 more charges, will be to select a foreperson who will preside over your deliberations and who will sign the verdict to which all of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after a thorough discussion of the case with your fellow jurors and a careful consideration of all of the evidence. During your deliberations, you must not communicate with anyone outside your group about this case, nor may you conduct any research. You have all the evidence in this case, and it would be improper to supplement it with any outside information. To assist you in complying with these instructions, the deputies will be collecting all of your electronic devices, including Apple Watches. I've seen a few. So we're going to take cell phones, iPads, anything that you could text someone or Google something. We'll hold on to it safely. They'll beep and boop back in my chambers. You'll get them when you're done deliberating. But during deliberations, it's you, the evidence, your notepads, the whiteboard, the markers, and nothing that connects you with the outside world. Going forward, should you need to communicate with me for any reason, it needs to be in writing. Write it on a note card, on a page from your notepad. Upon receipt of your question or note, I will confer with the lawyers and Mr. Dill, and I will share with you whatever response I am allowed by law to give. And I put that last little bit, allowed by law. You may have a great question, and my answer may be, you're going to need to work that one out, because legally there may be some things I can't give you an answer to. It's what you have been tasked with doing. So I'm not being difficult. I'm being guided by the law and input from the lawyers, but I will try to make the answers to your questions, should you have any, as helpful as possible. With that, I need all of you except for Mr. Bellew and Ms. Dobry, Dr. Dobry, to go back to the jury room. Deputy Gordon will collect your electronic devices. When you get all the evidence and the jury charge and the indictment, and the verdict form, you can begin your deliberations. And that'll just be 3 minutes. It's not going to be long. We've already worked through what's going back with you and what doesn't. But once you get all that from Deputy Gordon, you're off and running. And then let us know when you want to take a break. Breaks need to be the whole group. It is not okay for 3 of you to say, I need to walk down in the hallway and make a phone call. You couldn't do that anyway because you don't have a phone. But lunch will be lunch for everyone at the same time, whether you all eat together or you eat in smaller groups. Deliberations require all 12 of you to be present and engaged. We don't get a partial verdict of 6 and then the other 6 decide and you see if they match up. Okay? She'll go with Deputy Gordon.
Yes, I don't know. Sorry. That's one thing. The voluntary has to be listed under each file.
I give you, that all goes out. You two, wait. So we got our court reporter ready. You two are our alternate jurors. For now, you are our alternate jurors. If we lose a juror, if we had lost a juror, one of you would have become part of the deliberating group. If we lost 2 jurors, then both of you would have. We always pick alternates because anything could happen. There's a family emergency or who knows what, and we need 12 to get a verdict if we're going to get a verdict. You have heard all the evidence. You've seen everything that the other 12 saw. What I'm going to have Deputy Gordon do is set you up in the other jury room. You can keep your electronic devices, but no outside research. You're welcome to watch videos, do work, call people. Just don't talk about the case either between the 2 of you or with other folks, because we're keeping you on simmer. If we lose a juror for whatever reason, one of you will go in there. They'll need to restart their deliberations. They'll do that, and we'll move forward. But this allows us to try to complete a trial if we have an unexpected emergency with a juror. So when they break for lunch, you can break for lunch. You have lunch with them because they can't talk about the case during lunch anyway. And certainly, if there's a verdict Once that's been received, we'll get you in here. We're not going to forget about you. If for some reason deliberations spill over until tomorrow, before you go today, we can talk about whether you want to go about your business. If you could commit to being here, if you got the 911 from me, and you could be here within 30, 40 minutes. But if you going to work means, hey, it would be 2 hours to get here, then maybe you could stay home. Won't necessarily make you come back. But if we get a verdict today, we don't need to work through that anyway. Any questions about that? There's also their bathrooms in that jury room as well. It doesn't have a coffee maker and all that stuff, but these guys will be checking on you from time to time. And so they can get you a mini snack basket or something. Okay, thank you. So you should go in the jury room, grab your stuff, and then deputies will get you in that room. Thank you. Ms. Willingham, Ms. Beza, any exceptions to the charge?
No, Your Honor, but may I look at the verdict form? I know Ms. Willingham looked at it as well, but
Yes, but I just want to close the loop on the charge. Ms. Feely, any exceptions to the charge? All right, we're good with the charge. I don't know where it went. You can get me. I know where it went. Ms. Rivers has it. So you may look at it. We'll go off the record. You can take a look at it. And then if we need to discuss it, we'll do that. But let's let the jurors, why don't you get it while the jurors pass through?
Which case were you looking at? I'm trying to find where on the thing, which case were you looking at? I don't know which one.
Are you leaving the courtroom with the verdict form? Okay. So will the evidence be going out in that envelope?
Yes.
So the envelope is what's going and that other stuff is not. Okay. Where did the verdict form go?
it's right here.
Oh, okay.
It remained on the table.
Okay.
I didn't want to make a phone call in court, and we don't have to be on the record. I guess you can get on the record, but
So let's get on if we're talking about the verdict form, let's get back on the record. Okay. Ms. Willingham had seen the verdict form, said it was fine. You wanted to look at it, which is also okay. And you rushed out of the courtroom, presumably to talk to appellate attorney or something. Tell me your concern, if any, with the verdict form.
and it's not that I didn't want to make the phone call in the courtroom.
That's okay.
It's my understanding that the lesser included of voluntary should also be listed under felony murder predicated on aggravated assault, as the aggravated assault is the act of the kind of like the underlying act of the malice, which is shooting and killing.
So I've done some research on that as well. I don't know that you're wrong, but the case law is clear that if the jury finds Mr. Dill guilty of voluntary and of felony murder predicated on aggravated assault, I will vacate the felony murder predicated on aggravated assault. So there's not a risk there. There is a risk because the case law is also clear. If the jury finds the defendant guilty of felony murder on the firearm counts, voluntary manslaughter is not going to make those go away. And I think the clearest, most direct connection was murder voluntary. That's really what the charge is about, and that's what voluntary reduces. It's that that sudden irresistible passion. But you're correct, legally it would have an impact on a guilty of felony murder predicated on aggravated assault.
I got it.
Okay.
Thank you, Your Honor. I was reading the case up briefly, and that's why I made a phone call that we couldn't have both, but Your Honor already planned to vacate if that was the case.
Yeah, but better safe than sorry. The last thing we need is to get through a very largely clean trial, except for defense one. And then we have a hiccup with a verdict form. So I appreciate your concern. If you'd give that to Ms. Rivers, then we can get the evidence to the jury and they can start deliberating.
Yes, Your Honor.
Thanks. Do we know where Deputy Gordon went? Okay, we'll see. He'll be back shortly. Let me get a couple other things on the record. So I will need one phone number from the defense and one phone number from the state that we can dial that will get at least one lawyer back from both sides when there are questions or whatnot. You write it on a note card, whatever it is. But if I could get those two numbers on that one note card, then I'll share that with my staff. Mr. Dill, you will come back out into court anytime we're discussing something from the jury. So if you're back in lockup wondering what's going on, it's just they're deliberating. But if there's a question from the jurors or anything like that, that I need to interact with your lawyers on, you'll be out here for that as well. Okay? Deputy Gordon, that's ready for the jury. Thanks. It is. Ms. Beza gave it back. All right, so that's it. Anything else, Ms. Willingham, before we break for deliberations?
Nothing further, Your Honor.
All right, Ms. Feely? Okay, then we will be on break. I will mute the microphone in here so people can talk and it won't go all over the planet.
This is a video of the shooting.
Yes.
The Grady video is on here.
Can we bring Mr. Dill out, please?
Did that work?
It's really lighting up.
All right, we are back on the record in State versus Dill. I received the following inquiry from the jury, and so we're clear. Mr. Dill is in court with his lawyers, and we have the prosecutors here. The inquiry is, could we see, one, the video of the shooting, two, State Exhibit 114A and B, which I guess is neighbor video. Is that ring camera video?
That is.
Okay.
That's correct, Your Honor.
All right. And then three, autopsy report. So video of the shooting, State Exhibit 114A and B, and autopsy report. I'm not quite sure what the first one, I know what the words mean. There are lots of videos. I don't know if that's surveillance camera or ring camera. That seems to be something different from State's Exhibit 114A and B. So I may engage the jurors when they come out, unless you know already, lawyers, that the video of the shooting, that has to mean surveillance camera because the ring camera shows something different.
So there were two sets of ring camera. The video of the actual shooting was State's Exhibit 22, and State's Exhibit 114A and B is the surveillance footage from, is the neighbor's ring cam from earlier in the night.
So 114A and B is the white car and black car bopping around. No Ms. Willis Riley or Mr. Stafford.
The apartment video shows it from further away, the shooting. Right?
Correct.
Yeah.
Yeah.
So 22 is the only video footage that's in evidence that shows the shooting.
It's also in the apartment complex video. It's off to the side in there, but it is in that video as well.
Okay, so it sounds like 22 would be what we would tee up for video of the shooting. And we'll get feedback from the jurors. Is this the video you're talking about? I'll ask them that and they'll say yes. And we can play it start to finish. Because we're playing it start to finish, I'd ask that we push it through Zoom so that the audio, if there's audio, is part of that.
Yes, Your Honor, that was our plan if we got to this point.
Okay, and then 114A and B, it's a different ring cam.
It's the same ring cam.
It's a different
but
part of the day.
Part of the day.
Okay,
Correct.
all right. Do you have any objection, State, to having the jury watch 22, 114A and 114B again?
Objection from the state.
22 is, as I recall, just a few minutes long.
Yes, all of them are just a few minutes. I think 22 is actually the longest. It's, I think, 7 minutes in total, and 114A and B are each.
One is 6 minutes.
One is 6 minutes
And one is 4.
and
5
one
minutes.
is for about 5 minutes.
Okay, it's not nonstop from 8 p.m. till the shooting.
No.
Okay, all right. Ms. Feely, any objection to playing States 22, States 114A, and States 114B? What about the autopsy report?
Screen in front of the jury.
I don't have a strong feeling about it. They asked for it, which they did, so.
Okay, so your thought would be that the autopsy report would go back. You're not objecting to the ME report going back with the jury after they're done watching the videos? Okay, any objection from the state?
No objection. And it's not as to the autopsy report, Your Honor, so I don't know if you want to finish there and then I can ask some questions.
Let's finish with the autopsy report. So it sounds like we're amending the original decision to not have the autopsy report go out. Now that the jurors have asked for it, I'm hearing Ms. Feely say on behalf of Mr. Dill, defense is now okay with the ME report going back with the jury after they watch the videos. Correct, Ms. Feely? Are you all right with that, Ms. Willingham?
Correct, Your Honor.
Okay, now what did you want to talk about?
We just wanted to know if the video or if the screen moves, and
It-
if so, can it go in front of the jury?
It moves some. If you want to, we should move it some. I invite you to move it carefully.
Yes.
Okay. Thank you. Now the jurors are just going to think we forgot to give them the ME report.
Oh, it's okay.
Yeah, I don't think we should.
What's wrong?
See, they were saying, can we move over here, but
If you have to unplug it, don't do it, because I don't know what would happen after that. But this is an improvement, at least. For folks way down there, it'll be harder, but they can kind of self-select. Or we can play it once and then they can do musical chairs and play it again. Okay, when Ms. Rivers comes back, we'll bring the jurors in.
May I share my screen?
Please. Oh, do I? Yeah, I don't have anything shared. And when you share, did you click the little boxes about share video and audio?
Yes.
Great. Well trained.
Make sure it works. Yes, it's working.
Is that the ME report? Okay,
Yeah.
thank you.
Once I realized what it was, he was already.
sure.
I'm waiting for Ms. Rivers to be ready. All right, Ms. Willingham, are you ready for the jurors?
Yes, Your Honor.
Ms. Feely? Let's bring them in.
They should send out that email about training. Let me text. I can't even text Asia.
All right, adjourn. I'll do a friend.
Thank you, Deputy Gordon. You all can be seated. Ladies and gentlemen, I received your inquiry and the answer is yes to everything. Here's how it's going to work. States 22, which I assume you meant when you referred to the video of the shooting, is queued up right now. We're going to play it all the way through, not stopping. Some of you are closer to the screen than others. If we want to play it a second time, so 6 of you are closer and 6 of you aren't, that's fine. It's not a very long video. When 22 is done, we'll play 114A and 114B. When all of that is done and you've seen it as many times as you need to see it, shuffling chairs or whatnot, states 118, which is the medical examiner's report, will go back with you for your consideration. So, Ms. Beza, if you could please start 22.
Oh, this one man by your car. He moving. It's the guy by your car.
You looking on the phone?
Uh-huh.
Okay. It might be one, I'm not sure. Boy, you go. Oh, my man. Which one? Well, you put it out there.
Yeah, that's a big one right there. 13:35. All right, you want to look out the window? Open that TV. That's the white car. Okay, but they know what they know. I'm like, oh, that's my damn shoe. That's the white car.
What time was birthday, 35?
12:35.
So that 35 is 0:35. The time is random,
What they know was?
but yeah, none of them.
Oh, they got a guy right there.
Is that now?
Nope, I rewinded it. Hope he ain't bleeding.
Okay, you can't go back 5 minutes?
There you go. That's a girl. That's a guy. He's fine. He shot him. Oh, dang, hit your car. I think you hit your car.
You ran up from behind the shadow?
Uh-huh. They got the phone.
Right there.
That's a girl right there.
Shooting again.
That's downstairs there, ain't it? Hello? You okay? I figured I heard some bullets. Ringing my doorbell. Okay, somebody at my door. I'm calling right back.
What is it?
He said somebody landed down by your car, trying to get it.
Well, they better call police then.
Do we need to have people switch seats and we play 22 again? Okay. You just talk amongst yourselves so people get in the right spots.
And Your Honor, would you like me to play the whole thing?
I'm going to ask. Do you want it played entirely through? Is there a point after which we can stop, or what's your preference?
Yeah.
Well, when we say halfway, after the shooting is complete, there's then a pause after the white car backs away. So let's start at the beginning and play until the white car backs away.
Also, like maybe the last 2 minutes or so, just toward the end.
We might as well just play the whole thing. I don't want us to start in the wrong spot.
Oh, this one man by your car. He moving. It's the guy by your car.
Are you looking on the phone?
Uh-huh.
Mm-hmm. It might be one on that shot. You go, you go. What, my man? Which one? Well, you play it out there.
Yeah, that's a big one right there. 1335. All right, you want to look out the window? Open and see if they see it. That's the white car. but it ain't no way they know it. I was like, oh, I see that's my dang shoe.
What time is that thing,
12:35.
35 is here, 35.
What they know was?
Yeah, I'm not there.
Oh, they already got it right there.
Was that now?
Nope, I rewind it. Hope he ain't bleeding.
Okay, you can't go back 5 minutes?
There we go. That's a girl. That's a guy. They fine. You got him. Okay, hit your
Who's
car.
that again?
Okay, you hit your car.
You ran up from behind the shadow?
Uh-huh. They
You
got the
sitting
phone.
right there.
That's a girl right there.
Shooting again.
That's downstairs there. Hello? You okay? I figured I heard some bullets. Ringing my door there. Okay, somebody at my door. I'm calling right back. Cool.
What are you doing?
He said somebody landed down by your car. Trying to get it.
Oh, they better call police then.
Are we done with 22? Okay, let's go to 114A, please.
One moment, Your Honor.
Okay.
Playing 114A at this time.
All right. That was 114A. Does anyone need to see that again? Okay, 114B, please.
Done. Saying 114B.
So that says 115. Was that actually 114B?
Yes, Your Honor.
Okay. Anyone need to see 114B again? All right. Then what I propose is that you return to the jury room. Deputy Gordon will accompany you and he'll have states 118 with him for your review, which is the medical examiner's report. Anything else you need, just like you did, put it on a card and we'll address it as soon as we can. Thank you. All right, you're welcome to be seated. Ms. Willingham, anything from the state before we break again?
Nothing from the state.
Ms. Feely? Okay. Same situation, Mr. Dill. We'll get you back out here if anything like this comes up. You need to get 22 back up, please. Ms. Beza, yes. All right, Ms. Rivers, you ready? Okay. We're back on the record in State versus Dill. It is a little before noon. I received a second note card from the jury. It reads, "Can we view the video?" Question mark. Exhibit number 22. And then in parentheses, white car backing up. So my proposal is we bring our jurors back out and we know which exhibit they want. It's 22. And I'm going to ask if they want to watch the whole thing or just the part with the white car backing up. They are entitled to watch any part of it they want. If they don't want to, they don't need to watch the whole thing, all the better. But I will inquire of them about that. Any issue with that approach, Ms. Willingham?
None, Your Honor.
Ms. Feely?
No.
Okay, let's bring the jurors in, please.
All rise for the jurors. All jurors present.
Thank you, Deputy Gordon. Everyone else can be seated. Jurors, I received your second card, which asks to view the video again, but you specify exhibit 22, which is on the screen. And then there's a parenthetical, white car backing up. And I couldn't tell if that was letting me know which video you're talking about, or if there's just a segment of the video that the group wants to watch. It can be whatever you want, whole thing, a piece of it. Who's going to be the spokesperson?
Sorry, the beginning up to that point.
So start at time 0 and play until a white car backs up.
Yes.
Okay, got it. Do you feel like you know where that stopping point is, Ms. Beza?
Yes, sir, in around 2 minutes and 50 seconds.
Okay, and obviously if we stop too soon, you guys can say that's too soon. We'll play it once. If people need to shift around, we can play it a second time. Exhibit 22, starting from the beginning.
Oh, this one man by your car. He moving. It's the guy by your car.
Are you looking on the phone?
Uh-huh.
Let me see. It might be one, I'm not sure. Are you across? What, my man? Which one? Well, you're pulling out there.
Stopping in at around 3 minutes and 6 seconds into the video.
After the white car backed up. Ladies and gentlemen, do we need to play that again?
Yes.
Yes, rotate? Okay. You know the drill.
Oh, this one man by your car. He moving. It's the guy by your car.
Are you looking on the phone?
Uh-huh.
Let me see. It might be one, I'm not sure. Are you across? What, my man? Which one? Well, you're pulling out there.
About 3 minutes and 6 seconds into the video.
Same spot. Thank you. Do we need to play it again? Seeing everyone say no, I'll invite you to return to deliberate. I'm going to send Deputy Gordon in maybe 20 minutes or so to see if you want to break for lunch. And if you do, as long as one person is breaking for lunch, you're all breaking for lunch because we need all 12 of you together if it's deliberation time. Okay? Thank you.
All rise for jury.
Ms. Willingham, anything before we pause again? Ms. Feely? Okay, I'll let you all, someone will let you all know if the jurors take a lunch break, so you can know, you can really be on a break, and there won't be anything coming up for about an hour. I have a Zoom meeting that starts at 12:30, so we'll figure out before 12:30 what their plan is. They may say we're not gonna go to lunch till 12:45 or whatever it is, but we'll let folks know a little before 12:30 what their lunch desires are. Thank you. Okay. Ms. Rivers, are you ready? I'll get him out. I just want to, Ms. Willingham, anything we need to talk about before Mr. Dill comes out? Ms. Feely? All right, let's bring Mr. Dill out, please.
He's in the back. He's very well.
Oh, he is bringing him out. Okay. So those guys didn't look like they were moving at all, which I respect. I'm not your boss. I could get him on the phone. There's Hudson. Okay, we're back on the record in State versus Dill. Mr. Dill is in court with his lawyers. The prosecutors are here. Deputy Gordon tells me that the jury has reached a verdict. We'll be receiving that verdict in a moment. It is important that anyone who is here in court is convinced that he or she can sit quietly without reacting when the verdict is published. If you've got any concerns about that, I promise you, you'll get to hear what it is from someone who can stay in here and be quiet about it. If there are outbursts while the verdict is being published, these folks are going to remove you from the courtroom, but it may be through the all wood door rather than the side doors. I'm serious about this. It's important that we maintain decorum during this important process, whatever the verdict is. Hung jury, guilty, not guilty, split verdict. You need to receive that verdict respectfully. And if it's a cause for despair or celebration or something else, you'll have time to do that. It just won't be within courtroom 8D. Okay? Let's bring the jury in.
All rise for jurors.
Can I give you the 2 questions? Not a court exhibit. Thanks.
All jurors are present.
All right, you all can be seated. Thank you, Deputy Gordon. Ladies and gentlemen, Deputy Gordon tells me that you all have reached a verdict. Can the foreperson stand? Did you all reach a verdict in the jury room?
Yes, Your Honor.
Okay, and was it a unanimous verdict?
It was, Your Honor.
Have you, as the foreperson, completed the verdict form?
Yes, sir.
Can you hand it to Deputy Gordon, please? All right, thank you. If you would please publish the verdict, meaning read the verdict into the record.
Starting with count 1.
Yes, sir.
Count 1, Your Honor, we, the jury, find the defendant guilty of murder. Count 2, we find the defendant guilty of felony murder and aggravated assault. Count 3, felony murder, armed robbery, guilty. Count 4, felony murder, firearm by felon. Count 10, guilty. Count 5, felony murder, firearm by felon. Count 11, guilty. Count 6, aggravated assault, guilty. Count 7, aggravated battery, guilty. Count 8, armed robbery, guilty of armed robbery. Count 9, possession of firearm during felony, guilty. Count 10, possession of firearm by convicted felon, guilty. And count 11, possession of firearm by convicted felon, guilty.
Thank you, sir. Deputy Gordon, if you would please share the verdict form with Ms. Willingham and then Ms. Feely. Ms. Willingham, do you have any objections to the form of the verdict?
No objection, Your Honor.
Ms. Feely, any objection to the form of the verdict? Go. Ms. Nelson? Thanks. Ms. Willingham, anything else we need to address before I excuse the jury? Ms. Feely?
No.
Okay. Ladies and gentlemen, on behalf of the state, Mr. Dill, his lawyers, and the community, I want to slide it aside a little bit. I want to thank you all for your service. While this was a short case, it was not an easy case. The subject matter was very serious. A life was lost, and you dedicated yourself to this process. We're on time, worked hard, and deliberated thoroughly. We can't get closure, whatever closure means, and it's something different for everyone involved, and it's not complete for anyone involved. But we can't get past this open case and these open charges without you all participating the way you did. So I want to thank you for that. Deputy Gordon is going to take you back to the jury room in just a moment. Once you're back there, you'll be reunited with your electronic devices, as well as your two colleagues who were the alternates. I'm going to come back and thank you a little bit more. We've got letters that constitute proof of service if you need that for an employer or a significant other who's been doubting where you've been the last few days. It covers from Monday through now, and then we will send you on your way. But thank you again on behalf of everyone. I'll be back there in a minute.
All around the jury.
All right, everyone can be seated. Ms. Willingham, is there any reason why we should not go forward with sentencing at 3 o'clock today? I can't do it right now. I need to get the jury out of here. And then I have a couple other things I need to attend to, but my proposal is to do sentencing at 3 today.
That's fine.
Okay. Ms. Feely, any reason not to do sentencing at 3 o'clock today? Okay, Mr. Dill, we're going to keep you up here, back there. You'll be brought back out at 3 o'clock, and we'll have a hearing about how sentencing is going to work in your case. I will see you then. Do we want folks to leave in a particular way right now? You guys got it? Thank you. I figured you did. So, counsel, I will see you all at 3. I will also let the jurors know when sentencing is. If people want to have lunch and come back, I'll also let them know that you will be out here if they are willing to provide feedback. If you're going to be out here, if you're not, I won't tell them that. Okay. All right. If we do that, though, it's going to need to be just the lawyers who are here. So if you have family members who want to stay, I'm not going to bring the jurors back out. It's a public courtroom. I'm not going to make anyone leave, but jurors aren't going to come back out for feedback unless it's just the lawyers who are here and intern and supervisor. Ms. Rivers, are you ready?
Yes.
Okay. We can bring Mr. Dill out and we'll get on the record. All right, Ms. Rivers, are you ready?
Yes.
Okay, we're back on the record in 22 SC 181085, State versus Dill. It is a little before 3 on the 15th. Mr. Dill is in court with his lawyers. Our prosecutors are here. The jury returned a verdict of guilty on all counts around 12:40-ish, a little later, 12:45 today, this afternoon. And it is now time for the sentencing hearing. The way we'll work this is I'll turn to Ms. Willingham first to see if there's anything the state wants to present. I think there may need to be some certified copies of convictions, or at least one more than the two that are in evidence. Certainly any victim impact information. I know there are members of Mr. Stafford's family who need to leave. So if you want to have them talk first before everything else, that's fine with me. The important part is they get heard. And then you can certainly relay to them what the outcome of the sentencing is if they need to leave before we get to the end of that. But eventually the state will present its part. And then I will hear from Ms. Feely, anyone who's going to be speaking on behalf of Mr. Dill, if there's anything Mr. Dill wants to say, and then I'll impose sentence. Does that work for the state?
It does, Judge.
Okay.
And with that, I would like to allow the victim's mother to speak first.
Sure.
Because I recognize that you need to take a fight.
Okay. And the way that will work is it's just wherever you want to stand. It needs to be in a place where Ms. Rivers can hear you and take it down. So it doesn't necessarily have to be up at the podium. It could be right by Ms. Beza if you feel like you're going to be able to project. If it's going to be hard to speak out, then I will need you at a microphone, either at the state's table or up at the podium, okay? So why don't you start by coming and standing near Ms. Beza?
On
Can
November,
you, I'm sorry to interrupt. That's not very polite, but I need you to share your name so we get in the record. I know your connection to Mr. Stafford, but I need to get your name.
yes, sir. My name is Tamika Ziegler. I am Jonathan Stafford's mother.
Can you spell your last name?
It's Zeigler.
Thank you, Ms. Ziegler. When you're ready.
Okay.
And just to put my name on the record, my name is Wayne Williams, and I'm the victim advocate here.
Are you going to be saying anything?
If she do not finish, then I will pick
Then
up.
you'll take over. It's good that you're here. Thank you.
On November the 26th, 2021 was one of the best days of my life. And then became the worst day of my life. That day was Thanksgiving, and I was thankful to have all of my children with me on this day.
Unfortunately, that day came to a tragic end with the death of my son. And my whole life changed. My girl's life changed. My son's children's life changed, as well as the lives of their mothers. Since my son has been gone, his birthdays and holidays haven't been the same. All I can think about is the last time I spent with him and how sweet he was. We danced in the kitchen and sang together on Thanksgiving Day. Jonathan was my only son. He's the son that I prayed for. I asked God for him. And then, just like that, he was gone. It's like a piece to my puzzle missing. He's the missing piece. Jonathan was such a sweet soul. He loved his family and his 3 children. Which his last son being only held for 3 months of him being born, and my grandson will never get to know his father. He'll never get to say Happy Father's Day to his father or get to spend Father's Day or do things with his father that his son does, or even his daughter having her father walk her down the aisle or graduation, or just to be able to watch his children grow. I have to listen to my grandchildren cry out for their father, wondering when he's coming home. It's been so hard the last 2 years. I've had to look at memories come across my social media pages, or every day I have to talk to my son through an urn with his name on it. It wasn't easy going to fill out paperwork at the funeral home, going to pick out something for him to be cremated in. This has been one of the most hardest things I've ever had to do. I think that I would never be able to see my son again. I miss him every day. I wake up and knowing that I'll never hear his voice again to tell me that, hey, mama, what you doing? Oh, mama, I love you, lady. My son loved his mother.
My son loved his mother very much. I was the first lady in his life. This year, Mother's Day was hard for just all the other Mother's Day since he's been gone. I don't get that call from him anymore. My heart is so broken and I haven't been able to put it back together. And I don't know that I ever will. Jonathan had his whole life ahead of him. I was even told that he was surprising me to buy me a house. Well, Dad, he'll never get that chance to do that. I can't tell you how many nights I have woke up crying, miss my baby, or at work, and I think about him and I have multiple breakdowns. Because I think about if I would have just kept him at home with me, that I could have protected him from harm. There has been times where I haven't been able to go to work because mentally I'm not able to, or I just want to stay home and hold his arm in my arms and just cry and scream. But then reality hits, my baby is gone and he's never coming back. We'll never get to see him again or hug him again or hear his voice again. My heart breaks every day and sometimes I just want to just give up, but I can't because I have 8 beautiful grandchildren, my husband and my girls who I love and need, and they need me here with them. It's been God who has given me strength to get through this, and it is him that I will continue to carry my family through as we continue to grieve Jonathan for the rest of our lives.
Thank you for filling in, Mr. Williams. Ms. Ziegler, I appreciate you sharing that. I know it's not easy to be here. My hope for you and your family is that the proceedings that you've been here for bring a little closure. I know that they don't heal much, but shows that the system followed through on this, and at least there were people who were trying to achieve some measure of justice to make up for your family's loss. I'm glad that there is larger family. It's not just you, but you have your kids and your grandkids, and hopefully collectively you'll carry each other through this, because it will be difficult every Mother's Day, every birthday for Mr. Stafford, every Father's Day. The memory will be particularly sharp. I'm sorry that your family had to go through this.
Thank you.
Your Honor, pursuant to OCGA 1710-2, the state is prepared to present aggravation. The state has filed an aggravation notice, and that notice was filed on December 7th of 2022. And I believe two of the defendant's prior convictions have already been admitted into evidence as part of the trial. I'm not certain whether the court wants the exhibit numbers to continue, or if you'd like me to do a state's exhibit 1 for the purposes of sentencing, but we are prepared to enter indictment number 15 SC 138669, which is a conviction for a possession of a firearm during the commission of a felony, theft by receiving stolen property, willful obstruction of law enforcement officers by use of threats or violence, willful obstruction of law enforcement officers.
So let's number consecutively. So I think that would put us at 166.
That is correct.
States 166 will be the certified plea, conviction, sentencing, that packet for 15 SC 138669.
Yes.
Ms. Feely, any objection to the admission of states 166? It's admitted.
And Your Honor, as to 15 SC 139-324, the state is aware that the defendant was still on parole, which was set to expire on March 3rd, 2024, and that is pursuant to the parole certificate. We are not certain as to whether there is still a balance as to 14 SC 128-673. And based on our review of Odyssey, it appears that there is no balance for 15 SC
138-669.
Correct. Just wanted to make sure.
Let me ask Ms. Feely a question here. Ms. Feely, my thought would be if there is any probation parole tail left on any of the 3 cases, I'll work with Ms. Tucson. But assuming you're willing on behalf of Mr. Dill to waive any due process issues, that I just revoke the balance and close those out. I don't think it will affect anything, but I wouldn't want Mr. Dill to be unable to get from point A to point B within the Department of Corrections because, wait, he has to go back to Fulton to deal with a revocation. That ought to be a foregone conclusion, what happens with any balance on any of these 3 cases. Do you support that approach? Okay. Ms. Nelson and I will look into it, and if we need to revoke anything, we'll just revoke the balance and run it concurrently with the sentence here.
Yes, Your Honor.
Okay.
And with that, Your Honor, as the court is aware, the evidence that presented was very heinous. This was a very malicious attack. The defendant approached Jonathan from behind with a firearm and repeatedly shot him. And based on that, the state would be asking as to count 1 for a sentence of life without parole. As to counts 2 through 5, they would vacate by operation of law. As to count 6, it would merge into count 7 as a matter of law. As to count 7, 20 years to serve consecutive to count 1 pursuant to Drain v. State 265, Georgia 255.
Keep going, but I want you to stop after you explain count 7, please.
Yes, Your Honor. As to count 7, that count would not merge because in Drain v. State, the trial court did not err in failing to merge the conviction for aggravated battery with the conviction for malice murder. The victim's throat in that case was slashed at least 6 times. A rational trier of fact could have found Drain guilty of aggravated battery independent of the act causing the victim's death. In this particular case, Your Honor, when Jonathan was shot, the gunshot wound as testified to by Dr. Sullivan is not the gunshot wound to his leg. As testified by Dr. Sullivan, that gunshot wound to his leg could have rendered his leg useless. And based on that, and in comparison to Drain v. State, where the victim was, his throat was slashed multiple times. In that case, he was the aggravated battery did not merge and all of the slashes were to the throat. Here in our case, the gunshot wounds are to different parts of the body.
Can you give me the site again to drain?
Yes, 265, Georgia, 255.
Oh.
Yes, DRANE.
So you think that the aggravated assault would merge into the aggravated battery and not into the murder?
Correct.
Okay, and then the aggravated battery does not merge into the murder for the reasons you've said, and for legal support for that, you rely on drain.
Yes, Your Honor.
Okay, keep going.
As to count 8, life without parole, consecutive to count 1. As to count 9, it would merge into count 11 as a matter of law. As to count 10, it would merge into count 11 as a matter of law. As to count 11, 15 years to serve consecutive to count 1. For a total of 2 consecutive sentences of life without parole plus a consecutive sentence of 35 years.
So I think the consecutives will work a little bit different then. So count 1 is life without parole. Count 8 would be life without parole consecutive to count 1. Then consecutive to count 8 would be count 7 for 20 years. Consecutive to count 7 would be count 11 for 15 more years.
Yes,
Which
Your Honor.
got it. Okay. Understood. Got it. Anything else?
Nothing further.
Okay, thank you. Ms. Feely.
Started one, I don't know that it practically makes a difference, but the state did use 2 of the convictions listed on their recidivist notice to give counts 10 and 11. And for that reason, I believe they cannot use it for subsection A, 1710, 7, subsection A.
Okay.
And in terms of the indictment, we are asking count 1 for a life with parole.
So then we need to work through your argument. I'm familiar that there is case law, although some holdings have been reversed, about convictions being, I think the phrase they use is used up. So if a conviction serves as the predicate for something, then I guess your position is you can't also use it for recidivist purposes?
I can send you the case, but I can also give you the site.
Site would be great.
State versus Slaughter, 289, Georgia, 344. 289, Georgia, 344, case from 2011.
And you contend that that stands for the proposition that 2 of the 3 convictions listed on the recidivist notice can't be used for recidivist purposes because they're predicates for counts of conviction in this indictment, which would leave only 1 conviction, which would mean that I could only treat Mr. Dill as I don't know if it's A or C, one of those 2 recidivists, but more importantly, that has as its premise that I have to sentence Mr. Dill to the maximum, but I can probate or parole or whatnot. In other words, if we're just focused on aggravated battery, if aggravated battery doesn't merge, if Mr. Dill is a 1 felony recidivist, I'd have to have the sentence for aggravated battery be 20 to do something. It could be 20 to do 1. That would be legal, but it would have to start with the maximum number. Is that your understanding?
I believe so. So that would be C.
Sentence is unapplied where the defendant has to. I'm going to say something.
So yes, I think it only was.
So what, if slaughter says what it says and applies here, Mr. Dill would only be a 17-10-7A recidivist because we'd be down to one. And what 17-10-7A says is that any person who's been convicted of a felony, singular, shall be sentenced to undergo the longest period of time prescribed, but the judge may probate or suspend the maximum sentence. So 17-10-7A is a one felony recidivist, and it would work the way I described, that for aggravated battery, the sentence would have to be 20 to do something. It could be 20 years probation. It could be 20 to serve one, balance suspended, but it would have to start with 20.
I believe that it may be the reverse. I think
I've got the statute in front of me, and C, 17-10-7C, refers to offenders with at least 3 felony convictions. They are required to serve the maximum time provided in the sentence, and they're not eligible for parole. So if it was C only, and I were to say your sentence is 20 to do 5, Mr. Dill would do every day of the 5 and not be eligible for parole. When you combine the two, which is what the state says applies here, I have to sentence to the maximum, which for murder is life. But because of C, it would be life without parole. It would be non-parolable. That non-parolable piece is triggered by 3 or more convictions. And you're arguing that because of slaughter, even though Mr. Dill has 3 convictions, for purposes of recidivist calculations, 2 of them are used up or consumed by counts 10 and 11, in which case we only have 1 to work with. So it would only be A, which would mean 20 years to serve something on the counts that don't start with a life.
so. Count 1, we are asking for the minimum, which is life. We agree with the state that counts 2 through 5 by operation of law are vacated, and it's our position that counts 6 and 7 merge into count 1. And I haven't read the case, but it sounded like it said it wasn't error not to, maybe under certain circumstances, but we are asking to merge. And on count 8, we're asking for concurrent life. For count 9, we're asking the court to suspend the 5 years, and it's our position that counts 10 and 11 merge into each other. So we would ask for concurrent time on that as well.
So you don't think 9, Ms. Willingham said she thought 9 merged into 11. She had 9 and 10 merging into 11. Do you agree with that, or? Okay, so you agree that everything merges into 11, but 11 I thought was a 15-year term. I don't know that it's a 1 to 15. I thought it was it's a immovable object. It's a fixed term.
Yes, Your Honor, it's a mandatory 15 consecutive.
That was we don't do a lot of 133s, but let me look. That's my dim recollection.
Your Honor, I'm not certain if you want me to wait. But
I do want you to wait. I do. I will come back to you. Right. So 133. Someone found guilty of that shall be punished by confinement for a period of 15 years to run consecutive to any other sentence. So it doesn't say I can't suspend it or probate it, but it has to be a plus 15. So the least you could argue for, setting aside this recidivist piece, would be concurrent life sentences for the murder and the armed robbery, and then it would be plus 15, but you'd want that suspended
That's right.
if it is suspendable. Okay, so effectively a single life sentence. Question, what is your understanding of whether count 8 armed robbery, which I believe would have to be a life sentence because of the operation of 17-10-7A, even if you're right, and we're operating only under A, I'd have to sentence to life because that's the maximum for armed robbery. Is that a parolable life or not? Because if it was 20 years, those aren't parolable years.
It is for a long life sentence.
Okay. And you're thinking that because of you feel like you've read that before, or you're gonna, I'm not disagreeing with you. I don't know. We're clearly operating a very high altitude sentence here. Why don't you look at that? And Ms. Willingham, I'm going to turn back to you. I know we're not done, Ms. Feely. There may be things more you want to say, or family members, or Mr. Dill, but I do want to get straight what our sentencing parameters are. I'd love your thoughts, Ms. Willingham, about the recidivist piece and convictions being used up or consumed, and then anything else you want to say in response, not to lower or higher, but literally the procedural. Do things merge, not merge?
Yes, Your Honor. As to, in State v. Slaughter, it also addresses that, in contrast, the application of OCGA 1710-7C to a defendant who has 3 prior convictions and in a subsequent prosecution is convicted for firearm possession by a convicted felon does not excavate the sentencing range set forth. So the state would argue that those sentences would not be used, or those convictions would not be used up, and that he would still be subject to the recidivist.
Okay. Anything else you wanted to add about the mechanics of the sentencing in contrast to what Ms. Feely had to say?
Regarding the mechanics, we should stick with our recommendation.
Yes, Your Honor. Nothing regarding the mechanics. We would stick with our recommendation and just renew our argument as to why the aggravated assault and the aggravated assault should merge into the aggravated battery, and then the aggravated battery does not merge into count 1.
Okay. Ms. Feely, back to you. 1, did you find anything on that armed robbery piece? And then 2, are there more things you want to share, or family or Mr. Dill wants to share?
I don't think that it's parolable, fortunately, but
Okay.
I would like to share a little bit about Mr. Dill.
Sure.
As the court can see, he has very supportive, been several movies in your life, here to other courts, and this is nothing but a tragedy all the way. We're not going to belabor that point. Mr. Dill's 26 years old. He's worked jobs at most recently doing a Chevrolet in the Springs, but unfortunately, we understand that the court doesn't have a lot of discretion. So we are asking the court to consider, not that it's practically going to make a difference, but the minimum that is allowed, which is certainly life-changing.
Okay. Do any of Mr. Dill's family members want to speak? It's not in any way obligated or required. I just, if there was anyone who wanted to say anything, now's the time. But I'd ask you to come up and stand by Deputy Hudson. We'll have a better chance of hearing you if you are up there. And I need you to, you'll be talking to me. I don't want you can share words with other folks, but you and I are the 2 having the conversation, okay? All right. And you are Ms. Mahone Jones. We heard from you before. It's good to see you again, not under happy circumstances. What did you want to add, Ms. Mahone Jones?
want to add, I want to say to Mr. Stafford's family, to Ms. Ziegler, I truly apologize.
So Ms. Mahone, I need you to, you can keep saying what you're saying, but I don't, it's not appropriate to engage with other folks in the courtroom. So keep apologizing, but talk to me.
I just want to apologize to Ms. Ziegler, the mother, Jonathan Stafford. I apologize on behalf of my son, Carlos Dill, myself as his mother, and our entire family, that this was a tragic incident that took place, and these two persons went in a false path without the engagement of this Tatiana Williams. And I just want to say that my son is not, he's not a monster. He's a very loving son. And it's just that under these circumstances, the rage or the passion for someone caused or brought on such the act. But I just want to know, to the mother, my heart reaches out to her. I know what it feels like to lose a son, not in this incident, but I do understand. And I just want to apologize to the family, let them know that I'm deeply sorry for their loss. Again.
Thank you. I think that's important to share in a very real way, Ms. Mahone Jones. You're losing a son today as well. And so I understand and appreciate your emotion. Mr. Dill, you, of all the folks in the room, actually have the most absolute right to be heard. It's your sentencing. And if there's anything that you think I ought to hear, again, just like with your mom, it's you and me who will be talking. But you may have things that you want other people to hear. You may have nothing to say. You're not, just like with testifying, you're not obligated to say anything at all. But I would be remiss legally if I didn't check to see if there was anything you wanted to add before I sort out the sentencing. Okay. I need to, I'm happy to stay right here. I need to look at Slaughter and a couple cases that have applied it. I don't want to get it wrong and it gets bounced back for that. That's just real disruptive for everyone. I think in the end, it will be a little moot because of the conviction on count 8 and the fact that at a bare minimum, there's, I think, no reasonable legal dispute that Mr. Dill is a 17-10-7A recidivist. But I would like the sentence to be as legally correct as possible. So if you guys will just give me a couple minutes.
So if he had eye surgery. So.
Okay. In reviewing Washington versus State 311 Georgia Appeals 518, which came out many years after Slaughter and a couple other cases, including King versus State, 169 Georgia Appeals 444. I believe that Mr. Dill is in fact a 17-10-7C recidivist. It's not going to change much with the outcome here, but the one exception that didn't allow the state, prevented the state, precluded the state and the sentencing court from relying on a previous conviction to enhance a sentencing situation was if the fact, if we use this situation, if Mr. Dill had a conviction and then was convicted of felon in possession of a firearm, if 17-10-7A could be triggered by that previous conviction, then every conviction for possession of a firearm by a convicted felon would have to have a 5-year sentence. By definition, you have to be a convicted felon to be found guilty of possession of a firearm by a convicted felon. That first conviction that puts you into the status of being a convicted felon cannot also be used to recidivize you as an A recidivist, because then there would not be a meaningful range, which there is, which is 1 to 5. The sentence would always have to start with 5. And that's what Slaughter said. And in Washington, the Court of Appeals highlighted that distinction. If in a case like this, and Washington was the same, the state was seeking to invoke 17-10-7C, then we have a defendant who's already on a 4th or subsequent conviction and is not stuck in a scenario where he never had a chance to be sentenced to less than 5 years for a possession of a firearm by a convicted felon. I don't know how well I explained that. I feel like I understand it. I think Washington versus state supports my finding that convictions aren't used up in this context. They would be used up in the finding that Mr. Dill or defendant X is guilty of being a felon in possession of a firearm only in that 17-10-7A. It's you're really getting your second conviction, and that first one is what would trigger the recidivist provision. That's not where we're operating. So I think that the only sentence I can impose for count 1 is life without parole. That's the sentence I impose. Even if, so we have a backdrop here, Supreme Court, it turns out that I'm mistaken. Ms. Feely has interpreted Slaughter correctly, and we are operating only under 17-10-7A. I find that the killing in this case was so wanton and malicious that I would sentence Mr. Dill to life without parole if I had the option to do that. That's what this case was like. And I appreciate discussions about how passion was involved. But so we're clear if this gets bounced back because I was incorrect in applying 17-10-7C, which takes me out of the equation, and the statute mandates a life without parole. This murder, I believe, merits a life without parole sentence. You want to add something?
I just wanted to say, having reread it, I believe the court's interpretation is correct and allows us the amendment.
Okay. I think so too, but I'm not shy about saying this was about as senseless and cold a killing as one gets to see on video, and I don't like seeing it on video. It was calculated, it was staged, it was managed, and I don't fault Ms. Willis Riley for this. You all are going to have complicated feelings about her. She didn't shoot Mr. Stafford 6 times. If she was involved in setting it up, shame on her, and maybe someday she gets prosecuted. She didn't have the gun. She didn't pull the trigger. She did not kill Mr. Stafford. Carlos Dill did by shooting him a bunch of times after he was lying on the ground. No self-defense. There is not justification for this. And I don't think Mr. Dill needs to be back in circulation again, because I don't know that he'd be able to control his emotions again if he felt jilted by someone important in his life, and we wouldn't have another Mr. Stafford. And no one should have to go through what Mr. Stafford's family went through. Frankly, Mr. Dill's family shouldn't have to go through this again either. This hasn't been easy for them either. Counts 2, 3, 4, and 5 are vacated by operation of law. I believe that 6 merges into 1 and 7 merges into 1, and that's how I will handle 6 and 7. The sentence for count 8 is life without parole. That will run consecutive to count 1. 9 and 10 merge into 11. 11 is 15 years. I will suspend those 15. They have to run consecutive to count 8, but I will suspend those. Mr. Dill, I need to share with you your appellate rights. I am sure your lawyers have talked to you about this anyway, but I need to get it on the record. You have the right to seek several different forms of what we call post-judgment relief. Number one, and most immediately, your lawyers could file a motion for new trial on your behalf. I suspect they'll do that. They need to do so within 30 days. You'll need to talk to them about that. If they do that, they'll then come off your case, because one of the things a lawyer who will then be appointed to represent you, and you have a right to counsel for this round of appeals, one of the things that that lawyer will want to look at is, did Ms. Feely make any mistakes in representing you, so that that can be challenged in front of me. That motion for new trial will be argued in front of me. I'll rule on it. If I deny it, you then have a right to appeal your conviction to the Supreme Court of Georgia. And that lawyer who assisted you in your motion for new trial will also be your appellate lawyer for that appeal to the Supreme Court of Georgia. You can choose not to appeal any of this. You would still have a set of appellate rights known as habeas rights. That's basically bringing a civil lawsuit, and it wouldn't be brought here. It would be brought wherever it is you're being housed in the Department of Corrections. You have 4 years from the either finality of your judgment here, if you don't appeal this, or 4 years after the Supreme Court of Georgia affirms your conviction, if that's what they do. So your appellate timeline can be fairly long. You'll have a lawyer to help you, because I'll appoint one, for your motion for new trial and your appeal to the Supreme Court. You do not have right to counsel for your habeas challenge. You could hire one if your family chooses to do that, but one won't be appointed, one will not be appointed for you by the state of Georgia. So again, the most immediate would be you and your attorneys deciding to either file a motion for new trial or a notice of appeal. It's either or, don't do both. I will ask Ms. Feely and Ms. Wood to consult with you. And if you direct them to file one of those two, they'll do that. And then they're going to ask to be removed from the case, as they should be. So a different set of eyes can come look at your case and how this trial proceeded. Do you have any questions about the appellate rights I just described? Okay. Ms. Feely, you'll discuss those with Mr. Dill? And if he directs you to file a placeholder motion for new trial, you'll do that?
I have actually already done the preliminary motion for trial.
Okay, well then that's done. That stops the clock, and then the appellate section will take it from there. Ms. Willingham, anything else on behalf of the state?
Your Honor, the state would just ask for you to repeat the sentence as to the armed robbery.
Life without parole, consecutive to count 1. Ms. Feely, anything else in connection with Mr. Dill?
Just the credit for time served, it's been continuously in custody since November 26th of 2021.
Okay. Right, that never actually came up during trial as to how he went into custody. Mr. Dill, you get credit for every day you've been in custody, and that'll be on your sentencing sheet. If we get the wrong date, Ms. Feely's going to flag that for us, and I'll make sure the correct date is put in there. The last thing I want to say is thank you to everyone for being as calm and collected as you could during this difficult time. I know there was one point when I had to fuss at a few of the folks who were here from Mr. Stafford. That's not me not understanding what you're going through. It's me wanting to try to maintain decorum while the jury's here. The last thing you would want is a mistrial because someone acted out, the jurors got concerned, and Ms. Feely said they can't continue to hear the case. That's the only reason why I was asking you to just sit tight during some difficult times. I'm going to ask the folks who are here for Mr. Stafford to leave first. when they're ready to leave. And when they're gone and the deputies say it's okay, then I'm gonna ask Mr. Dill's supporters to leave. But we're gonna leave at different times and head safely in your own direction. Thank you. Yes.
Let's just speak with them in the hall.
You can bring your stuff.
Okay.
Thanks, Judge.
Hmm?
You need anything else from us?
Was there any useful feedback from the jury?
Yes.
Yes. So let's have Mr. Dill's folks go and then we can talk about it.